The affidavits of Celestine Opio and Arnold Ochieng Oginga, while containing sensational information, were not credible, as the registrar's report confirmed that all the forms 34A attached to those affidavits and purportedly given to them by the agents at select polling stations were significantly different from the originals, certified copies, and those on the public portal. The purported evidence of Celestine Opio and Arnold Oginga, sworn in their respective affidavits, are not only inadmissible, but are also unacceptable. It has been established that none of the agents on whose behalf the forms were being presented swore any affidavit, that there is nothing to show that they had instructed both Celestine and Arnold to act for them. Yet the two have gone ahead to depone on matters that are not within their knowledge. This court cannot countenance this type of conduct on the part of counsel who are officers of the court. Though it is elementary learning, it bears repeating that affidavits filed in court must deal only with facts which an opponent can prove of his own knowledge, and as a general rule, counsel are not permitted to swear affidavits on behalf of their clients in contentious matters like the one before us, because they run the risk of unknowingly swearing to falsehood and may also be liable to cross-examination to prove the matters deponed. We must remind counsel who appear before this court, or indeed before any other court or tribunal, of the provisions of sections 113 and 114 of the Penal Code that swearing to falsehoods is a criminal offense, and 2, that it is an offense to present misleading or fabricated evidence in any judicial proceeding. Section 114 of the Penal Code states, and I quote, "Any person who swears falsely or makes a false affirmation or declaration before any person authorized to administer an oath or a declaration upon a matter of public concern, and at such circumstances that the false swearing or declaration, if committed in a judicial proceeding, would have amounted to perjury, is guilty of a misdemeanor." One of the most serious losses an advocate may ever suffer is the loss of trust by judges for a long time. Such conduct amounts to interference with the proper administration of justice. The contents of the affidavit of John Mark Githongo, which may contain forgeries, are also dismissed for not meeting the evidential threshold. Those averments contain no more than incredible and hearsay evidence. No admissible evidence was presented to prove the allegation that Forms 34A were fraudulently altered by a group situated in Karen under the direction of persons named in the affidavit and video clip attached to it. As a matter of fact, these two affidavits amount to double hearsay and incapable of being proved at each of the rears. We turn to Form 34A for Gasharaigo Primary School, which was sensationally presented by Madam Judy Soweto advocate to show that one Jose Kamango accessed the RTS and interfered with the result contained therein. This also turned out to be no more than hot air, and we were taken on a wild goose chase that yielded nothing of probative value.